guess the other follow-up to that would be is that you're being laid off. And if you either sign the non-compete at that time or you receive no severance pay. What about that?
Well, some employers do put it in severance packages. That is, you're not under a non-compete, but we're letting you go and we're going to give you a severance pay. The law doesn't require you to get any severance pay, okay? But they're going to offer you severance pay. They're going to offer you a severance package. And in exchange, you need to maybe sign a release for them. You're releasing them of any claims you have against the employer, and or sign a non-compete. Well, that's very circumstantial. You know, it depends on the individual. And it depends what they're trying to non-compete. Are they trying to get you to get completely out of the industry, or are they trying to get you to just not do a particular kind of job? Sometimes these non-competes are you know, very narrowly written. They'll have a geographic restriction of, say, 5 to 10 miles, which you can work around. Or the activity that's being restricted is something that's pretty narrow and say is something you were exactly doing with that employer. And if you want to do something different and you think you'd be better doing something a little different, sure, maybe you sign it to get that severance. You know, I think it depends on what your job prospects are at that point. It depends on, you know, how you and your family need that severance money. You know, obviously it's not good to be entering into an agreement not to compete at that point, and I think it depends, you know, how bad you need the severance package in exchange. Yes, ma'am.
Many people worry about work references when they're looking for employment, and it used to be a law in Missouri that that a business would have to give you a service letter. Is that still in place?
That still is in place. You have to request the service letter in writing within a year. And there's all sorts of, well, there's not all sorts of, but you have to use magical language. You have to reference the statute. You have to send it certified. And something, a common mistake I see is someone will go to a lawyer and the lawyer will send it and say, you know, my client is Ron Larry's and I want you to give him a service letter. Well, that's doesn't follow the rules. So there's very technical requirements to get that service letter. But the law does give you a year to do it, which relatively speaking among the states is a good amount of time. And in reply, they have 45 days to reply and say what dates you worked, what positions you held, what your duties were, and why you left, okay? So yeah, if you're worried about them saying negative things, that is something you can proactively do, get that service letter, and you know, use that when you're applying for jobs. If you're worried about the new HR person or your supervisor or maybe saying negative things about you, if they have that policy where they let people really talk about you, you can proactively use that service letter to say, you know, hey, no reason to call on either the company I used to work for. Here's a service letter right here. I'll save you time. So that is one option. Another thing too, you know, as Mike brought up the severance agreements, well, one thing you can do when you're negotiating a severance package is, hey, will you give me a letter of reference I can take with me? Usually companies are happy to do that, and you can work with them on the language, and maybe that's another way you can get it. Yes, sir.
Is there any criteria or formula that the company has to use during the layoff?
It depends on whether it's a mass layoff under the Federal WARN Act. Okay, so if it's a big plant closing or if it's a mass layoff. But normally it's just, you know, we got to let these 3 project managers go. If you're talking about that situation, no, there's not any sort of formula they need to use. Sometimes they will use formulas just to make sure that there's not an adverse impact on people who are protecting class. Because the employer doesn't want it to be that, well, you know, we looked at all these legitimate reasons, we're going to let all 5 of these people go, and by coincidence, and it could be coincidence, all 5 of those people are over 40, all 5 of those people are African American, and the people we're keeping are all under 40 Caucasian people. Gosh, you know, it played out and looked really bad, and they don't want things to look bad like that, because that's just going to invite questions and perhaps claims. So the law doesn't impose on them any sort of obligation to use any sort of formula. They just can't consider, you know, the reasons we talked about when making that decision. Yes, sir.
I recently received and ultimately didn't accept the contract offer and included a fire at will provision. And you talking about that, I didn't like the way that sounded today. I don't know about it.
Employment at will is a notion that's still alive. I won't say it's alive as well. But employment at will is a notion that's been around for a long, long time. And it basically means you're employed at the will of the employer, and you're employed at your own will. If you want to resign, nothing special you have to do, you just have to tell them you're resigning. In much the same way, they can let you go at their will. And they don't need to give you a reason. They don't, at will, theoretically, so that they don't need a reason. It could be a bad reason. It just can't be an illegal reason. So it can't be because you're a man, you're over 40, and you're Caucasian. It can't be because of that. But as long as it's not an illegal reason, they can let you go at their will. So exceptions to the at-will context are these legal protections that everyone has as long as the employer has over 6 employees, has 6 or more employees. Or if you have some employment agreement that you entered into that says, or if you're working as a union member under a collective bargaining agreement, that you can't be let go at will, you can only be let go for just cause. You see in professional sports and in coaches, you hear about employers, organizations, schools being liable to continue paying for, say, for a coach who was let go, and they have to keep paying in the future. Well, that's because that's not an at-will relationship. It's one of those exceptions to it where there's an employment agreement that probably says something like, this person can only be let go for just cause, that is for malfeasance or for misconduct. And so if the school was letting the coach go because he's just not cutting it and they don't like the football team's record, they can let him go, but that's not going to rise to the level of for cause, so they have to continue paying him. But almost always, we're all under at-will relationships, which means they can lay you off or let you go for whatever reason.
To my knowledge, the state of Missouri is an at-will state.
Yes.
And so even if you're just getting an welcome to such and such company, please be advised you are an at-will employee. So it might not even state it in the contract, but also I know that it's also in the employee handbook in most cases. So
Yes.
it's there, whether it's up front or in some other document that you may or may not have paid attention to, but to my knowledge, Missouri remains that.
Someone else?
At one time in St. Louis, there was a pro bono law firm that offered protection to musicians and artists. Does that still exist?
In the city of St. Louis?
Yes.
I'm not familiar with that. That would offer protections to musicians and artists. You mean as far as their job protections?
Or contracts with musicians, for example, entering a recording contract, for example.
That's going to be controlled by private agreement, and I'm not aware of if the city of St. Louis still has any sort of requirement or obligation in that regard. I'm sorry. Yes, sir.
Yeah, Brian, maybe you could elaborate on this. If a person in transition has a, let's say a criminal blemish on his record, maybe a DUI, one, is that person obligated to put that on a resume, or only to respond if asked by a interviewer? And is it grounds for an employer to not hire a person based on a criminal say, one incident in a criminal situation?
Most of the time, employment applications are going to say, have you ever been convicted of a felony, something along those lines. Read very carefully what it says, because they're all a little different. Some, may say, have you ever been convicted of a felony in the past 7 years? Others will say, have you ever been convicted of any crime? Some will say, have you ever been convicted of or pleaded guilty to or pleaded no contest to? So read it very carefully, because if you pleaded guilty to something, strictly speaking, you weren't convicted of it, okay? So just answer the question that's asked, I would say, first of all. If they don't ask, if it's one of these organizations that for some reason doesn't make you fill out an employment application or it's not on there, I don't think you're under any obligation to volunteer that, okay? But if they ask, obviously you answer the question they ask. Yes, it is grounds for them to disqualify you for it, but they better have a policy in place beforehand that says, we don't hire anyone, who's had any sort of felony, or maybe any sort of felony that directly goes to honesty or concerns of violent crime. So they should have some sort of policy in place beforehand. But yes, it's not a protected category for you, not for you personally, but for someone who has some sort of criminal conviction. So it is okay to discriminate on those reasons. But as I said, I would give you the tip of read very closely what they're asking, because you may be able to say no. Yes, ma'am.
I haven't been here all because I've been working in the office, but have you done any work regarding the ADA and people who have hidden disabilities? I have hidden disabilities. A lot of people do it, and especially ADHD. I don't have that, but learning disabilities, and some people might have a heart murmur or something. And people discriminate because they don't know, they're ignorant about things.
Yes.
And I just wonder, have you done anything in that area? And I'd like to talk to you later too. Okay.
Yes, and we talked about that a little before. Disability does include physical disabilities, whether it's overt or whether it's hidden. It includes, I said mental disabilities. That would include, any sort of, cognitive, mental, motor planning disorder that a person would have, whether it's overt or not overt. And the question is, can the person perform the functions of the job they're applying for with that disability?
It's a question, a lot of times employers make up their mind before a person can't do it, especially with learning disabilities, because that is a whole, every person's different, everybody's brain works differently. And a lot of employers tend to jump to conclusions and they don't know the facts. And and if you say something, then you're already out. But how do you deal with them and dealing with that kind of thing?
Well, if you can do the job, then you're entitled to be considered like everyone else.
Yeah.
But it's more than that. Even if you can't do the job as it is, as long as you could do the job with some sort of, as I discussed before, reasonable accommodation,
Yeah.
whether it's more time or whether it's a device that you would be given, if that is reasonable for you to have and that bridges the gap and lets you do the job, then you're entitled to be considered just like everyone